Hello everyone. Today, Tilman Müller from our Hamburg office and I, Ronja Schregle, will discuss the EU Commission's draft SEP regulation. The draft was first leaked at the end of March, and on April 27th, the Commission then published the official version. Both documents triggered a lot of criticism by industry stakeholders and immediately became a hot topic in the patent community. But before we dive into the details of the criticism, Tilman, could you maybe give us a short overview of the content of the SEP draft regulation?
Sure. There are basically two key elements. First, an SEP register is supposed to be set up at the EUIPO, and the draft regulation provides that an SEP can only be enforced in the EU if a family member is listed in that registry. The second key element is a procedure to determine FRAND terms and conditions between two parties. So both the implementer and the patent holder can request such a procedure at the EUIPO. The SEP regulation provides that this procedure is mandatory before an SEP can be enforced in court. Any claim brought before the UPC or a national court is inadmissible unless a notice of termination for such a procedure can be shown.
The first pillar, the SEP register, caused a lot of controversy, and I can see why. A key element of this register is that there shall be regular checks whether the patents contained therein are indeed standard essential. What strikes me as a patent litigator is that this question, whether a patent is standard essential or not, is a highly complex issue. So not only does it require a deep technical understanding in the relevant field, but on top of that, it involves complex legal questions which can be handled differently in different jurisdictions. When you think about the number of patents that would have to undergo this essentiality check versus the number of experts suitable to do this essentiality check, it becomes obvious that it's hardly practicable in a meaningful way.
And the second pillar, the FRAND determination, is obviously at the center of every SEP litigation. Let's not forget that in most cases, the parties are able to agree, but in those cases that go to court, this is really the key element.
And in cases that do go to court, however, parties do not ask the court to determine FRAND terms. Why do you think that is?
I think it's because the parties realize how difficult that is. If you look at recent cases such as Interdigital versus Lenovo, you realize how time-consuming and cumbersome this is, including economic expert reports, analysis of dozens of license agreements, and so on and so on. And in the end, no one knows what result you're going to obtain. Also, if FRAND is arranged, as at least the German courts see it, how can you determine one single set of conditions to be FRAND?
Given that having a third party, namely the court, determine FRAND terms is already an option now, but that option is hardly ever, in Germany one could say never, used in practice, makes me wonder whether SEP holders or implementers will be happy to have the EUIPO, an organization which so far has no patent expertise, decide on FRAND terms.
Yes, I think that is one of the key questions that this draft raises. Why is a FRAND determination procedure made mandatory, although neither implementers nor patent holders have shown much interest in this option in the past? But I generally wonder why the Commission believes that such a massive regulatory intervention is needed. In the empirical assessment report published by the Commission in parallel to the regulation, it is expressly stated that there is no empirical evidence that implementers are discouraged from developing products or SEP holders are discouraged from participating in standard setting by the current legal environment. Also, there's no empirical evidence that there's any negative effect on consumers. So the question is, which problem is the Commission actually trying to fix here?
Well, it is still a long way from this draft to a final regulation. And this will certainly stay a hot topic in the SEP community.
Thank you very much, Ronja. And if you would like to know more about the details of the draft SEP regulation, please refer to our respective IP reports. Thank you very much.